We're on the record.
Morning, Madam Chair.
Thank you. This is a meeting of the Baltimore County Board of Appeals regarding Laurendale Club of Ruxton, located at 7611 Laurendale Club Road, zip code 21204, case number CBA 25-002. It is a deliberation that's been convened with Sharon Bernardi. I'm serving as chair, and my co-panelists this morning are Mr. Michael Stelmack and Mr. William Paulshock. And this deliberation is regarding a motion for, well, actually, the respondents move to dismiss this matter on the grounds that the petitioners have no legal right to maintain the appeal because the petitioner is appealing the approval of a permit for which the petitioner has no standing. And they are asserting that the board lacks jurisdiction. And according to the notice, it's regarding a miscellaneous permits, approvals, inspection of an appeal. The director of PAI's determination that a floodplain management variance is not required for the proposed fencing in the floodplain pursuant to Baltimore County Code Section 32-8-503A. And we did hear the matter, at least the arguments on the matter, and then we are now reconvening for this public deliberation, which is being held via WebEx. And I believe I did state that today is December 19th, 2024, and this matter began at 9:32 a.m. So thank you all for reconvening today, and I know we had some time to review the arguments as well as all of the support for those arguments. And we can proceed with, I can just start with I can start the deliberation, and please jump in at any point in time, and then of course I want to hear from you, because I was looking at more from a procedural perspective, and you may have a different approach for how you reach your conclusion. And so I will just start with as I said previously, what the respondents were contending, in their motion to dismiss, and it's around whether or not the board has grounds and whether or not the petitioner has standing to even bring the matter. And as I was contemplating that, if in fact the only basis for the appeal is whether or not the petitioner has standing pursuant to Baltimore County Code Section 35-2-302E regarding the permit piece, then I would conclude that the petitioners do not have standing because according to the code, only the applicant for the building permit may appeal to the County Board of Appeals, and that's for the review of a denial, revocation, suspension, and other matters relating to the permit. And if that's the case, then the board would lack jurisdiction to hear the case. But the petitioner's attorney, Mr. McCann, on behalf of the petitioners, did not argued also that it was not an appeal of the building permit, and he acknowledged that there wouldn't be any right to appeal that, but in fact that they are appealing the determination that PAI made regarding the permit. And in his written arguments, he stated that irrespective of the connection to the issuance of the permit, that the petitioners believe that determination is appealable. And then I started to look at within whether or not the appeal is timely, if in fact they had the right to appeal it. And I am persuaded by the respondents in that the appeal was not made timely. There were two, there was one appeal that was filed on June 27th, 2024, which was exactly 30 days after the permit was issued. The permit was issued May 28, 2024. That appeal did reference an appeal of the permit, which they did not have standing to file. So um, PAI director did not accept that appeal and returned the payment. And then petitioners filed what they say is a clarification of the original appeal. But I am persuaded, as I said, by the respondents that that second quote unquote clarification is in fact a second appeal, and that was not filed until August 5th, which is not timely. And to allow them to make a clarification that is actually a different argument from what the original appeal that was submitted is, in my opinion, collaterally stopped. And as the respondent stated, is an attempt to get a second bite at the apple. Um, and so for that reason, I would grant the motion to dismiss. But I am also, of course, interested in what you feel, because the merits of the matter, if we were to move forward, are within the jurisdiction of the board, and so I wouldn't dismiss something. I think it's, I don't want to do that, make that type of decision lightly. I think it's um, very important to hear those types of matters, but if it was filed timely, we would have that opportunity. So that was my rationale, and sorry to go on, but wanted to hear from both of you. Did you want to begin, Mr. Stillman?
If you please. First of all, thank you for indulging me with a little more time to think about this, and thanks. Appreciate the parties letting us convene today. I have a slightly different take on this after having sat down with it and thinking about it for a little while, and I think it does break down into, I guess, the two issues. One is the notice of appeal timely and is it formatted properly? And then the issue of, do the appellants have standing one way or the other? So I want to, I guess I'll do it in the same order as you, which is we'll talk about do they have standing first? Okay. And um, Mr. McCann argues that this appeal is not controlled under 35-302, which is appeals of permits. And um, he argues that it's controlled under 32-3401, which is sort of a generic, what we use is sort of a generic appeals from decisions of the director of permits, approvals, and inspections. And there's sort of two different rules that apply to each of these two different kinds of appeals that is relevant. So that's why I want to talk about them. Okay. So the when it comes to permit denials, the only party that has standing to appeal is, and I mean, I'm not going over stuff we've talked about before and other people have talked about, but I just want to lay out my thinking here. Okay.
Absolutely.
Um, the people who have standing to appeal permit denials are only the applicants. And it says they can only appeal a denial, revocation, suspension, annulment. It doesn't say who's allowed to appeal the grant of a permit. And the appellants, or no, I'm sorry, the original applicants, their argument is that no one has the right, essentially, to appeal the grant of a permit. Um, and sort of secondarily, one of the rules within that same rule is that the notice of appeal has to state the grounds for the appeal in clear and concise terms. And that's one of the issues you touched on. So I'm going to come back to that in a second. The generic rule for appeals, 323401, the standard is different. It says anyone's aggrieved or feeling aggrieved by a decision of the zoning commissioner or the director can appeal the decision to the Board of Appeals. And the rule for that is it's still 30 days, but it just says you have to file the notice of the appeal in writing with the department. It does not say it has to be in clear and concise terms. You don't have to lay out all your reasons. You just have to lay out you're filing an appeal. And so I think the issue is tough because it's a separate section of the code, but I do think it's convincing that it says anyone who is aggrieved by a decision of the zoning commissioner can file an appeal to the Board of Appeals. And I think the issuance of the permit is a decision of the zoning commissioner. And I would not be persuaded about that, except that there is a case on this topic that we were not briefed on, but that I found anyway. Um, and that case is called United Parcel versus People's Council, which is 336 MD 569 from 1994. And this is an appeal of the Baltimore County Board of Appeals about the construction of a UPS facility in northern Baltimore County. And it's an appeal from the grant of a building permit. And in this case, one of the neighbors appealed the grant of a building permit to the United Parcel Service. And the arguments are very similar to here. Now, in this case, the neighbors were definitely late in filing an appeal and were relying on a different argument as to why they were not late. They basically said we didn't find out until much later that the permit was granted. That's not true here. They really did file an appeal here within 30 days of the permit being granted. But in so the case was overturned ultimately on the issue of the timeliness in United Parcel versus People's Council. But the court had no problem with the neighbors appealing the issuance of the permit um, based on 323401. Basically, I think the strong implication in this case is that they had standing to appeal, even though they were not the ones who applied for the permit. And so I don't see anything in this case that says that someone who wants to appeal the grant of a permit can't. And so I'm sorry that that was not available to us ahead of time. And obviously, under our rules, I'm not allowed to like reach out to you and be like, hey, read this case, right?
Right.
And the fact is, it was not briefed before us. So, I mean, I don't see any authority that says this case is not good anymore. But I think it is persuasive that that the issuance of the permit counts as a decision. And the decision in this case to choose to not require the issuance of a waiver or variance for the floodplain issue is part of that decision that got made when the permit was issued and not when Mr. McCann wrote independently to the department, which I think is one of the things that the movements are saying. And I think support for that is in this opinion. And again, I think that the notice of appeal is within 30 days. And I think that the format of the appeal is sufficient to give notice that an appeal has been filed for the issuance of the floodplain variances or the lack of having required them to get a floodplain variance or waiver. I think the language that he uses in the appeal makes it clear that that's what he's talking about. And I think the conversations that he's had previously with the department should make it clear to them that that's what the conversation is about. So I don't think anyone didn't know that that was what the appeal was about. And I don't think that they should be held to the sort of higher standard of a clear and concise terms in the appeal, rather than I think they should just be essentially held to the terms of notice of appeal, which is what they did. Um, and then is it timely? Yes. I mean, I think that they filed it within 30 days. I think it was good enough. I think that they have standing. I don't think that the department should have sent back his money, the money, and I don't think they should have um, sort of dismiss the appeal summarily, because I don't think they have the jurisdiction to do that. I think the proper way to handle it would be for them to note the appeal and then for the opposing party to file a motion to dismiss with us. Um, and there is no justification in the record for why it was returned. We are only left guessing, was it returned because they sort of decided, the department decided that it they didn't have standing themselves, and I don't think it's their prerogative to say who has standing and who doesn't. I think they should have noted the appeal one way or the other. I think that's kind of where I am with it.
Yeah, I was not aware of the case and definitely appreciate you bringing that to our attention. Mr. Paulshaw?
This, and Mike, it was an excellent presentation on the research and everything you did. There is a few ifs and could have been in some of that was described. Um, but from what I am reading by code of statute and code and language that I read, I would have to agree with Madam Chair in dismissing. So that's the way I feel on this.
Now, what I will say is that, as I said in the, when I opened, that I am more reluctant to dismiss um, on procedural type matters, especially, at this point preliminarily. I think that the case that you brought to our attention, as well as, well, I guess regarding the case, it makes me feel that it would be beneficial to hear from the PAI director, and others, so that we can get additional information, uh, and instead of us making these presumptions of what they were thinking, what the intentions were. Um, it also gives additional time to review that case and see how closely it aligns. And I also see benefits in hearing the merits and still making a determination if, in fact, a higher authority felt that it was premature to dismiss and want us to later hear it on the merits. So, I mean, Mr. Polshak, I am open to denying the motion at this juncture, and then we can schedule the hearing. We can, of course, hear additional arguments as part of that proceeding. We can also hear the merits of the case and then still make a determination after we hold the hearing, and wanted to get both of your thoughts on that.
Yeah, just let me be clear real quick. I don't want to, what my thoughts on this have nothing to do with how I feel the ultimate issue will be decided. I don't have an opinion about that, so it's not an endorsement one way or the other of the ultimate issue of the case here. It's just I do feel as though the standing issue, like I said, that the parties do have standing here, which is what we're talking about today. So, um, yeah, I would deny the motion.
Um,
I do believe that the case, I'm sorry, go ahead, Mr. Pausha.
the legislative body, um, put these things in place for Baltimore County Council. Um, I'll agree with, the pursuit of everything, but this is Baltimore County and the legislative body that and the statutes that we go by. And in following that, um, I would still have to dismiss this case.
Mhm. And Mr. Stomach, can you help me on um, the standing piece based on,
Yeah,
your summation of the case? Then I am inclined to agree based on your interpretation, or not interpretation, but your briefing of the case, that the petitioners have standing. I, if you can help me with the timeliness piece, and I understand your arguments that they're not required to state the reasons for appeal, just request an appeal. But in the original request, the petitioners referenced the permit itself. So if they had not referenced that at all, I think that they were trying to appeal the permit, the granting of the permit. Can you help me there? What I'm thinking, I don't want to, speak for you, is that based on the future correspondence, it was that, of course, during the permitting process, there had to be a review of the 100 floodplain requirement and the guidelines around that. And by issuing the permit, then that determination is therefore appealable. So it was implied that the original appeal also included any decisions around the 100 floodplain
that's correct.
requirements.
And actually, the United Parcel case kind of touches on that a little bit, essentially that the issuance of the permit is the decision. And the decision not to require a variance or a waiver is bound up in that permit because the decision is not really made until the permit is issued. That is the decider. But well, the going to the notice of appeal, the June 27 letter from Mr. McCann says, please let this letter serve as a notice of appeal of the issuance of permit number yada yada and determinations related to proposed fencing in the floodplain at the subject property. And I think that those determinations are the implicit determination there is whether or not to require a waiver or a variance. And what he's saying is, you did not require them to get the waiver or the variance. I'm appealing those decisions. And I think that being done within 30 days of the issuance of the permit is good enough. I don't think, I mean, I think that the letter later on clarifying this was because it got denied originally. I don't think he really had to clarify it, but I think, you know, uh, later on, he wrote a letter saying the appeal is of PAI's determination that a floodplain waiver is not required for proposed fencing in the floodplain of the subject property. And I mean, that, you know, again, everyone knew what he was talking about in the first letter. It's exactly what he just said when he clarified it in the second letter. So, to my thinking, just based on the terms of 32.3.401, I think that's good enough.
I
And
just
again,
quickly took a look at that letter. Go ahead, Mr.
I
Paulson.
don't, would it be helpful? I know that, would it be helpful to take a minute to read the case? I know that I'm just springing on this you here, and maybe you might have a different feeling about the case, you know?
I'm fine with your briefing on the case. I'm just taking a moment again to look at the original letter of appeal. So if you just give me a moment to do
Sure.
that. So of course, we did not have the case previously. And based on the briefing that you provided, Mr. Stelmack, I I do see that there could be justification for the timeliness issue. I mean, you made it very clear the standing piece, based on the generic op-
You cut out there, Madam Chair. Madam Chair.
We lost you, Madam Chair.
I'm sorry, you
Oh, you're
lost me?
back. You're back.
Oh, okay.
You were cutting out for a few sentences.
Oh, sorry about that. I was reading the appeal letter, and as you said, it's the issuance of the permit and determinations related to proposed fencing in the floodplain at the subject.
We lost you again.
Madam Chair, we lost you again there.
Lost me again. Are you able to hear me now?
Yes.
Okay. I wish the parties did have that, so that we would have had that ahead of time, but based on your briefing,
Well, and
um,
I think that the I'm sorry to interrupt you. I think the logic holds up independently of the case, which is there's no other situation. Well, you know, it doesn't, the code for the issuance of the permit doesn't say who's allowed to appeal a grant. And we have a separate statute that says who's allowed to appeal decisions of the director. So, and I mean, you know, so I think it holds up regardless of the case. So I'm sorry, but carry on.
I understand there is an argument for that. I would prefer to, and denying the motion, reference that authority that you cited in the U.S. Parcel Service case as we draft this. And I know that they're just general rules, and I don't know if in that, at some point in time, that's something that we should visit, because I do have a concern if parties are able to appeal matters and not have some statement of what they're appealing, so that we don't have issues of collateral estoppel. But that's just a personal comment that I'm making. So I will agree with you, Mr. Stelmack, on your arguments for denying the motion. And I don't know if Mr. Polshak, if the deliberation has changed your position or not. And if not, then please state that for the record, and then we can move
It
forward.
really has not changed my position in this, but I agree with Madam Chair on your decision. So, you know, I think we're done, and we'll hear it down the road, I believe.
Thank you. And as we said before, I mean, that's what a deliberation is. It's not always clean. It's a conversation that we have to hear one another's opinions. And I feel that this was a very healthy discussion, and we'll make certain that the order definitely documents what we stated in the deliberation and our rationale for deny the motion. So thank you all for joining, and
Thank you, Madam
this
Chair,
concludes.
and
Thank you, Madam Chair.
Mr. Polshak. Thanks for hearing me out, and have a good afternoon.
You too.
Yeah,
Thanks.
and have a great holiday, guys.
You too. Happy holiday.